So this is the Ministry of Remedy hearing for 2020-1000/0004. This is regarding the unlawful incarceration, really, of every single individual minister or not of your energy and matter and movement that is being unlawfully incarcerated due to COVID. So we put an application together to the administrative system, who are responsible, obviously, for administering and protecting such a belief, a claim, an unsubstantiated claim, which has caused the unlawful incarceration of everybody under category D prison conditions. So it doesn't matter whether you've been really unlawfully incarcerated by going police or any other agent of the administrative system, or whether you've been incarcerated in Cardiff prison, for example. And even if you've been released from a prison, from a secure unit, you've been only released into category D prison conditions of a non-geographical corporate state, using a false claim of COVID as grounds and cause. If you can just everybody can just put themselves on mute, because I'm going to click the link and I'm going to share the screen. Okay. So if anybody wants to change anything that you've got at the moment, Darren. So this is just an application hearing to hear why really is it still being applied for. And obviously the reason why it's still being applied for is because of what I've just stated there, that we're still obviously subject to unlawful claim, unlawful incarceration, under the heading of COVID. So, just going to click this link and find it now.
Good morning, Minister.
Right, we're just going to join this meeting now. So if you can all just put yourselves on mute. Thanks.
Right, I guess, I've been on Minister Mode 010, can you hear me?
I can, yes.
link.
Can you hear me? Minister Imogen 010. Thank you.
Yes, thank you. I've got a hell image. All right, great. All right.
I'll stand for universal law.
It's CO 1813 and 14. One oral application of both oral application of motion 11.
Can I first just check who I have here now? I understand someone who identifies themselves as the applicant in the case of the MOR ULCT is here. Is that right? Is that you, sir? Oh, I see. Okay, right.
Imogen 010 laid the claim.
Sorry, that you identified yourself as Imogen 010 and the person who has laid both of the claims on the back as a litigation friend.
I'm not a person. I have laid the claim on behalf of the Imogens who are unlawfully incarcerated.
Yes, thank you. And can I just check the other gentlemen who are here in court? Are you parties to these claims or simply here? Right. Okay, thank you. And Ms. Heary, so you're here for respondent. I've received your note this morning. Thank you for assisting. Yes. So, well, first, just to make clear, as you will have seen, the applications, there are two applications for a writ of habeas corpus for the release of the persons described as Imogen 128 and Imogen 1191. And those applications were considered on the papers by Mrs. Justice Thornton, and the applications were dismissed. And then in response to the two emails dated the 26th of May 2021, which I take it were from you, Imogen 010, taken those as being an application for, or a request rather for applications for habeas corpus to be reconsidered at this hearing. And so it's for that purpose, for those applications to be reconsidered at this hearing, that we have the hearing today. Now,
Can I just ask a question?
the applicant, yes,
The defendants.
could you tell me who that is, as I can't tell?
I'm at Minister Imogen 010, and I'm
Thank you.
the defendants in this matter. The case file paperwork that was actually sealed was from a previously laid claim, and the national insurance account that was used with help with fees is not the correct account that is backing this case today, these cases. in between the first initial filing, the defendants changed and the additional defendant was cited as COVID. Now, on the document that you have in front of you, you'll see there's two claims. One of them has got a national insurance account numbers beginning WM, and that is the one that was stamped. But the actual claim that we have filed cites COVID and was filed at a later date after the original filing of habeas corpus writs were denied due to various reasons, one of which being the national insurance account WM was actually deemed invalid. Whether that has any bearing in any matter anymore due to the standards set by the administrative system as a whole or not, I will leave that for your determination.
Yes, okay, thank you.
So I would like to
Now,
ask, who is here on behalf of the defendant COVID?
Nobody is here representing such a defendant. Mr. Tahiri is here on behalf of Gwent Police, is that right?
Yes, ma'am, she comes.
Because it was Gwent Police who released the MVNs into the custody of the Cardiff HMP prison. And then from Cardiff HMP prison, they were further incarcerated using the title and the grounds and cause of COVID. They were then released from Cardiff prison into category D prison conditions, upheld by agents of Her Majesty's government, this HMCTs. And the unlawful incarceration is now being implied to be under the grounds of COVID still.
Now, can I ask you, you're seeking to act as a litigation friend. Now, one of the applicants, as I understand it, one of the two applicants is actually here remotely, but by the video screen. So are you seeking to act only as the litigation friend of Imoven 1191 and Imoven 128 is able to act on her own behalf? Is that right?
No, I hold the assignment of consent and the authority to act on behalf of the equitable rights of both of those creditors.
In order to act as a litigation friend, ordinarily, what is required in accordance with the civil procedure rules is an undertaking that you are willing to pay any costs that may be ordered against the applicant. I haven't seen an undertaking in this case. Have you given such an undertaking?
The undertaking is set out in the UCC1 filing in the core bundle, which is a 10 quadrillion slave token debt that is secured against Her Majesty's government and all agents thereof, with filing reference 2020-056-5342-1, filed on the 25th of the 2nd, 2020, inside the Securities Exchange Commission in Washington, making Universal Law Community Trust secured party creditors of Her Majesty's government, agents thereof, including, but not exclusively, HMCTs and all legal fictions thereof.
Yes, now that's not an undertaking that you will pay any costs order made against the applicants, is it?
That's an account.
Is that something?
That's to
Sorry, is that an undertaking you are willing to give?
Yes, it is. So I'm willing to give part of that securitization lien debt to stand surety to any charges to be discharged against.
Yeah, no, I'm not asking about any liens or UCC1 filings. What I'm asking is whether you are willing to give an undertaking that if a cost order is made against either applicant, that you are willing to pay it.
I'm willing to discharge the charges in exactly the same way they were created.
Now, an application for habeas corpus is an application for a person who is detained to be released. Is it suggested that either IMOVN 128 or IMOVN 1191 are currently detained?
It is suggested that every single being within the non-geographical state once known as the UK is unlawfully detained, using COVID as cause and grounds.
Yes, and so now IMOVN 128, who's here online, IMOVN 1191, who's not here as I understand it, neither of those persons is currently in a prison or other detention facility. I understand the way that you say you put it, but in terms of being detained by whether it be the police or prison service or anyone of that kind, neither of them are detained, is that right?
All of us are detained unlawfully by the administrative system in operation via HMCTs, using COVID to unlawfully detain us and deprive us of our rights, one of which being able to attend even a simple court hearing by presence. So the definition of unlawful detention or secured units could be extended to incorporate the boundaries and the imaginary borders of UK. So although they may be released from a secured unit titled HM prison, they have been released into category D prison conditions enforced by agents of HMCTs, who we are the secured party creditors to, and who we have not granted an assignment of consent or an authority to act.
Yes. Now, in relation to the question whether or not you're able to act as a litigation friend, what is the basis for suggesting? I mean, it's clear that IMOVN 128 is not incommunicado because I've just spoken to her. What is the basis for suggesting that they are unable to communicate directly with?
Well, first of all, you just made a presumption that you'd spoken to a being represented by MOVN 128. The whole process and the definition of what is valid ID is also what is included in this particular case. The origins of all administrative, legislative, civil code procedure requires an act of fraud in order for it to be initiated by coercing individuals to claim something they do not have the right of use of, being a legal fiction, for example. Minister Venn is a legal fiction that HMCTs, Gwent Police, and all other agents thereof do not have the right of use of. And yet we have seen it utilized in an attempt to create commercial intercourse, void a valid contract between legal fiction companies, titles, agencies, which are secured and obsolete. So the presumption that you have spoken to somebody representing a legal fiction is the very cause and grounds for this matter, and the requirements for it to be considered only by the administrative system in order for it to give an order to all agents thereof to stand down in the coercement of legal immatured creditors of Universal Law Community Trust, and to prevent any further unlawful activities enforced upon the people of our communities by uniformed agents of legal administrative systems enforcing commercial code, and they're referring to it as pseudo law.
One other aspect in relation to an application to act as a litigation friend is that it's something that only applies when a person, well, is either a child, which, as I understand it, doesn't apply in either of these cases.
Can I just interject at that point there? The definition of child, a legal minor, anybody who is unconsciously consenting to commit fraud upon their souls by lay a claim to a legal fiction that is not theirs to use is in the administrative civil code system considered to be an incapacitated legal minor, is it not?
Well, I mean, it seems apparent that neither of the applicants is a child. So the question I was going to ask is, I mean, a protected person is someone who lacks legal capacity within the meaning of the Capacity Act, the Mental Capacity Act 2005. Are you suggesting that either of the applicants lacks capacity, and if so, within the meaning of that act, and if so, what is the evidence of that?
It's an assignment of consent, and the assignment of consent of these particular legally matured beings have actually severed any contract or implied contract with any administrative system and assigned their consent of everything that was deemed to be defined as into another trust. So it's not so much as whether they are incapacitated or a legal minor. It's the fact that the administrative system is implying that they are.
Is there anything else that you wanted to say in support of the applications for habeas corpus?
The whole origins of all administrative systems process comes from and is initiated by an unlawful deed. And therefore, it's not about coming here to make an application for any legal recourse or remedy, because we know from the point of origin of an act of fraud that nothing lawful can come from such a point of initiation. So the habeas corpus and the application here is in reference to COVID and any minister of their own energy and matter in movement who is misidentified as a person or a legal fiction by any agent or agencies of HMCTs, Her Majesty's government, or any corporate state. And it's that we require the habeas corpus for, to prevent any further unlawful incarceration by any unlawful means whatsoever.
Thank you. Was there anything else, or is that's everything that you wanted to say?
That's everything that I would like to say in this matter.
Thank you. Could I just check with Imogen 128 whether there is anything that you wanted to add on your own behalf?
I think Imogen 101 has adequately explained the situation, and I'm quite happy for her to continue to do so.
Thank you.
I have a question.
Yes.
Where is the HMCTS's assignment of consent and authority to act in any matter?
I'm sorry, I don't understand. What question are you asking?
I'm asking where is it?
To act?
Where is it that you get your authority from to sit with such titles?
Well, the High Court clearly has jurisdiction to sit and consider. You have made an application for habeas corpus. You've made an application to this court, and this court therefore has to sit and rule upon the application that you have made.
But the application would not have had to have been made had the administrative agents not been coercing every living being into committing fraud for them then to exist in order to then prosecute them and create the cause and effect, and then imply that this has got some kind of legal remedy. So I'm asking again, the assignment of consent and the authority to act comes from where? Forced commercial intercourse.
Thank you. I hear your submissions. I'm going to give the.
I asked for this evidence by email prior to this rendezvous forum in reference to the assignment of consent and the authority to act that would have been granted to the agencies HMCTS and agents thereof from the secured party creditors who are Universal Law Community Trust. We simply haven't granted any assignment of consent, and we have only had to apply this process to prevent any further unlawful acts being continuated in the name on definition of legal administrative systems that are obsolete.
Yes, well, I hear your submissions. The process doesn't involve asking questions of the court. It involves making submissions, and I've heard your submissions now. And so now the process involves, I will turn to Mr. Tahiri, who's representing Gwent Police. Mr. Tahiri, thank you for your the inquiries made on behalf of the Chief constable. You'll have heard the way the application is put. So, I mean, in terms of anyone being directly detained by when police or otherwise by any prison, I mean, it's readily apparent that nobody is, and I'm grateful for the inquiries that you made. Is there anything else that you wanted to say?
I'm sure you know what I have to say already in terms of knowing the law, but I want to do my duty to the court.
Yes.
In terms of the record, legal submissions with which I can assist.
Yes.
Relationship. I'm grateful to my lady for making clear at the outset of the hearing. My understanding as well that this is the application on behalf of the claimants under CPR 87.42, requesting reconsideration of the decision of Mrs. Justice Thornton to dismiss on the papers the applications for writ of habeas corpus in relation to these two individuals. And the basis upon the reasons given by Mrs. Justice Thornton in dismissing these applications on the papers were that the application does not sufficiently explain the grounds on which it is made, the identity of the person on whose behalf it is made, or why he or she is unable to bring the application in herself. And that has, my lady has helpfully, if I may say so, indicated that emails were sent asking for that to be looked at again. In relation to the law, insofar as I may assist with the law, there's one procedural point. I see that my lady's already alive. And then 2 points of substance. The procedural point is first that such an application should, as a rule, be made by counsel or solicitor advocate, but the litigant in person may urgency be allowed to apply. There's a long line of authority which I can insist to back that up. In my respectful submission, no particular case of urgency has been identified to show why the person should be allowed to apply in this case. In any event, we have Imogen 128 as they've been described on the video, and you've heard from someone who can speak on their behalf. I appreciate that the court has deemed it as something of an application to act as litigation friend.
That was on the basis of that's what's ticked in both the habeas corpus application forms. Litigation friend, the box is ticked.
I see. I'm grateful for that indication. Yes, well, certainly my submission would be that the requisite criteria for granting litigation friend status are not laid out in the event. And perhaps it's pertinent to note that under 87.2, the documents that are to be provided on CPR 87.2, the documents that are provided at the outset of an application for purpose are supposed to make clear the nature of the detention. And if the detained person is unable to make a statement, then why? To paraphrase what the rules saying, you might well think that that has not been made clear, and certainly in the case of one or two individuals, solicitor counsel. So that's the procedural point in terms of the standing of the applications that you've been presented with, the submissions you've been presented. In terms of the substance of the matter, 2 points. First of all, both the common law and by statute, writ of habeas corpus may be granted only on reasonable ground for extradition being shown. The authority for that is 1671 Chief Justice Morgan, and also Hawkhouse's case in 1820. So what's required at this stage for writ of is reasonable ground for the issue of the writ. And just to put that in its proper context, when one goes further to the next stage, looking at what happens when a writ is issued and it's returned to a writ, and if one considers the substance of the matter, if one gets them, in those circumstances, the burden of proof would be on to show a prima facie case that the detention is unlawful. And then if they did that, the burden would pass to the restraining person to show that the restraint is lawful. And the relevant standard of proof would be the civil standard of probabilities. But of course, because grave issues of personality involved, the grave probability is quite high. So it's quite a burden in terms of burden of proof, and in terms of what is required to get to establishing, well, even if there was a writ, that there's a prima facie case. But to get the writ in the first place, there needs to be shown reasonable grounds for it to be issued. Now, in this case, I'm grateful for my lady's indication that your ladyship has seen the note setting out the best of the ability of Went Police to understand who these individuals may be, and indeed whether any individual is detained, and therefore, in respect of which one has to first be detained for there to be question as to whether the detention is lawful, and then whether habeas corpus even applies. There seems to be an acceptance that no one is detained in the sense of being held by a prison or certainly by Gwent Police. So in these, and what's referred to is, in my respectful submission, an unmeritorious submission in relation to COVID and in relation to legal fictions and the like. And so in my submission, in those circumstances, we are a very, very long way away from reasonable ground being made out for the issue of the writ. And indeed, I would go further and submit that the applications, the requests for reconsideration are both totally without merit. Thank you very much.
I would just like to add that I agree completely with what the gentleman just said there, and those are the very grounds for the reason why the writ should be issued. The fact that we're talking about legal fictions being used as a valid methods of identifying individuals within our community, and the fact that the definition of unlawfully incarcerated can be ambiguous are the very reasons why this writ for habeas corpus should proceed, because it is not just that by the laying of the writ was Gwent Police mentioned. There was also Her Majesty's HMP Prison Cardiff, and there was also COVID and all other agents thereof. As for procedural rules, there is no due process in anything that stems from an act of fraud. So the relevance to the grounds and having the merits is exactly what he's just set out and defined there. All of those things are being defined as legal systems and mistaken as law. And it is for that the merit that it constitutes such a definition as that are the grounds for a writ of habeas corpus to be applied, because of the ambiguity of by who and under what grounds are beings lawfully or legally detained. The fact that we can't even come to the court, the fact that we can't breathe oxygen without paying a tax, the fact that we can't pass through the ports.
You say you're not entitled to come to court, but you were.
I didn't say entitled. I didn't say entitled. I said that we had to compromise our rights, which would imply that we are unlawfully incarcerated somewhere by something, implying that they have more jurisdiction than what the law has. Those are the grounds for this habeas corpus, to bring all of those things into light and have them examined under the law as to whether an administrative system or agents thereof have any authority to act whatsoever, never mind, quote, procedural process. There isn't any.
Yes. Thank you. now give judgment on the applications. There are two applications for a writ of habeas corpus, the release of the applicants before the applicant in the first application with reference CO 1813/2021 is described as, quote, Imoven 128 misidentified as person unknown, internal quote, soup, close internal quote, unlawfully incarcerated at unknown prison, close quote. The applicant in the second application with reference CO 1814/2021 is described as, quote, Imoven 1191 misidentified as Dawson John, unlawfully incarcerated at Cardiff Prison. Respondents to both applications are identified as Gwent Police Constabulary and agencies and stakeholders in HMCTs, and it's been made clear that the defendants are also identified as COVID and as the prison HMP Cardiff. The person making the application on behalf of the applications of the applicants today has identified herself as Minister Imoven 010, although the applicant in the first of the two claims, Minister identified as Imoven 128, has also appeared via video link. Mr. Tahiri of Council has attended the hearing today on behalf of Gwent Police, and I am grateful to the respondent for attending and to Mr. Tahiri for his assistance in seeking to elucidate matters. Both applications were dismissed on the papers by Mrs. Justice Thornton, sitting as the immediate judge on the 26th of May 2021. She said, quote, the application does not sufficiently explain the grounds on which it is made, the identity of the person on whose behalf it is made, or why he or she is unable to bring the application herself, close quote. The applicant or the person seeking to represent them took issue with that order in two emails sent on the 26th of May 2021, and the court has treated those emails as an application pursuant to CPR 87.42 for the habeas corpus applications to be reconsidered at an oral hearing. Accordingly, the applications have been listed before me today, sitting in Cardiff Civil Justice Centre. The applications have been heard as a hybrid hearing with a number of people attending court, so others attending via CVP. Both applications appear on their face to be brought by a litigation friend. That is the box that is ticked in both habeas corpus applications. In the first application, the litigation friend is identified only as Imoven, with reference made to Universal Law Community Trust. In the second application, the litigation friend is identified as, quote, Graham Harkett, all rights reserved, close quotes, and again reference is made to Universal or community trust. A litigation friend is someone who conducts proceedings on behalf of a child or a protected party. It is not suggested that either of the applicants is a child. It's certainly clear that a Moban 128 who has spoken at the hearing today is not a child. A protected party means a party who lacks capacity to conduct the proceedings, that is, lacks capacity within the meaning of the Mental Capacity Act 2005, see CPR 21.1. There is no evidence that either of the applicants lacks capacity. What is said instead here is that Imoven 010 has represented them on the basis of their consent, but that is not a basis for finding either that those applicants are protected persons. Imoven 010 is able to act as a litigation friend, or all of those who are cited within the application forms are able to act as a litigation friend. In the applications, it is contended that the applicants are incommunicado. It was suggested that both applicants were held in prisons run by HM Prison Service. Those held in such prisons are not held incommunicado. They are able to bring proceedings themselves and regularly do so. There's no evidence at all that would not have been the case in respect of either of these applicants. If at any stage they were held in prison. But in any event, what is now clear is that neither of the applicants is held in any prison or detention facility. So it is readily apparent that they are not incommunicado.
So the UK corporate state is not a prison, and you can travel freely without having to compromise yourself or to breach your rights.
I am giving judgment.
You're presuming, you presumed your way all the way through this. And I'm trying to reserve your rights as well at this moment, because you are incriminating yourself, madam.
CPR 21.4 specifies who may be a litigation friend without a court order. Quote 3, if nobody has been appointed by the court, or in the case of a protected party has been appointed as a deputy as set out in paragraph 2, the person may act as a litigation friend if he A, can fairly and competently conduct proceedings on behalf of the child or protected party, B, has no interest adverse to that of the child or protected party, and C, where the child or protected party is a claimant, undertakes to pay any costs which the child or protected party may
which I have offered to do as the party standing surety. I am the party standing surety
from assets of the child or protected party
to protect this party.
Quote,
I stand surety to these individuals as their protection.
As the applicant's litigation friend have not given the undertaking.
So they're just going to carry on by presumption here, to completely ignore the fact that in order for them to even exist, they have to imply that everybody is incapacitated. So we have just got this individual here stating that Minister and events are not lacking in capacity.
debt is owed, and so in effect, that if cost order were made, there would be a willingness to set it off against an enormous debt running into quadrillion pounds. But certainly no undertaking was given in accordance with 21.43C. Nor have they given any clear information about who they are or what connection they have to either of the applicants, such as would enable the court to consider whether they have an interest.
So they've just ignored their own
or
UCC one here,
to
their
act
own
as a litigation friend.
SEC systems,
In any event,
and
it
Uniform
is
Commercial
manifest
Code as
from
having no
materials
standing,
placed
which
before
is why
us,
we will
submissions
rebut
that I
this,
have
obviously.
heard,
We require
today,
the consent
that those
authority to
purporting
act,
as
which they've
a
completely
litigation
ignored,
friend,
exemplifying
cannot
that they
fairly
haven't got any,
competently conduct
and
proceedings
also
on
that
behalf of
the
either
individuals using the title M event
CPR
are no longer to be
87.2
considered
provides,
incapacitated.
quote, 2, the witness statement or affidavit must A, state that the application is made at the instance of the person being detained, B, set out the nature of the detention, C, subject
And they're
to
now
paragraph
telling you
3,
all
be
how
made
to file
by
your
the
habeas
detained person.
corpuses
3,
for
if the
your
detained
release
person is
from
unable to
COVID
make the witness
restrictions.
statement or affidavit, the witness statement or affidavit A may be made by some other person on behalf of the detained person, and B must state the reasons why the detained person is unable to make the witness statement or affidavit. In this case, a witness statement has been made by someone describing themselves as Minister Immovable. It reads, quote, I'm laying this claim on behalf of 1191 or 128, mistakenly identified as legal fictions Dawson, John, and Versuk. The application contains my witness statement as particulars of claim, and the reason why I'm filing this and not them is for the simple logical reason that as a cap corpus is required, it would imply that they were unlawfully incarcerated with no access to resources to do this themselves. Here is my sign of nature. Apply it wherever upon the big rock. It would not be needed if the police were legally trained. And as they are not, then they are aiding and abetting the criminal acts of legal being implied as lawful. Release our ministers all rights reserved. The witness statement is not in proper form verified by a statement of truth, nor does it state that it is made at the instance of either applicant, nor does it set out the nature of the detention, or beyond the bare allegation that the applicants have no access to resources, give any explanation as to why the applicants are not able to make the witness statement or affidavit themselves. In addition, the grounds of the application are wholly unclear. The details of claim in relation to the person referred to as Moving 1191 are in these terms. Writ of habeas corpus, this is notice to the jailer administering Note 1191, currently being held unlawfully at HMCTs Cardiff, upon the charges against him were made by debtors to universal law, on Her Majesty's government and HMCTs, HMP being legal fiction secured by universal law, on the fact that Note 1191 has no contract with Crown Corporation or any other agencies thereof, on the process of administrative systems being ignored, on the evidence presented to the police when county court and Cardiff court being regarding the right of use of property that's movement of the on the rights of use of the property being peacefully surrendered in exchange for debt, on the occupants who were unlawfully being armed, on a mode attempting to prevent a crime being enacted, on the complete ignorance of the law by police attending the scene, on the impersonation of police aiding and abetting armed intruders who executed an unsigned order and claimed it was a signed writ, on the man impersonating the police failing to conform with its oath to protect the rights of our communities, on Gwent Stabbery being a private company registered in Dunn and Bradstreet, on Jenkinson having no assignment of consent, therefore no author's consent to act, on the recording confirming there was no signed writ or any sight of any writ in the case file or Cardiff court being attached, upon a divine writ being issued by Ministry of Remedy for the arrest and detention of those breaking the law while impersonating it, on the credit file being secured, on all legal fictions being secured by filing 2020-056-53421, including this company and all agencies that of this detention is unlawful. According confirming no writ in A, on the case being heard on Monday by some unknown court by methods notwithstanding lawful definition, and the coronavirus now being used as force to keep the moving 1191 unlawfully detained, on the disregard of coronavirus immunity certification being served on both prison and courts. The movement's unlawful detention requires an immediate investigation into the lawfulness of this matter by those responsible for the execution of such unlawful writs and orders requiring immediate release from prison. Close quote. The details of claim in respect to the person referred to as a Moven 1 to 8 are in materially the same terms. What is clear from the submissions made to me this morning, as well as from the investigations and inquiries that have been made by the Chief Constable, is that neither of the applicants is detained at all. What is suggested on behalf of the applicants is that every person within the state of the UK is detained using COVID as cause or grounds. That submission is manifestly wholly without merit. The applicants, it appears, may have been the subject of arrest at Alston Park premises by officers of Gwent police. Neither of them is currently detained at all by any of the respondents to these applications. For the reasons that I have given, my those applications pursuant to CPR 87.5 as the starting point for any application for habeas corpus is that the applicant is in fact detained, and there is manifestly no basis for suggesting either of the applicants is detained. They also certify both applications as totally without merit. In addition, I make clear that the proposed litigation friend, whether identified as Imoven, Minister Imoven, Graham Harkett, Universal Law Community Trust, or Imoven 010, is not a suitable person to act as a litigation friend in proceedings brought on behalf of either applicant, neither of whom is a protected party. As I have dismissed both applications as totally without merit, in accordance with CPR 23.12, I must consider whether it is appropriate to make a civil restraint order. Now, what I will say is my starting point is that at this stage, it's not something that I propose to make, but I will hear you if there is any application at this stage for one. Mr. Tahiri, is there anything you wanted to say in respect of that?
My lady, I'm not specifically instructed to seek such an order, but perhaps I can also take this opportunity to raise with the court another related point.
Yes.
Which is that, as a rule, on such an application, costs are in the discretion of the court to be exercised judicially, as per section 51 of the Senior Court Act 1981. Now, I acknowledge that in this application, it's not in every case the costs will be awarded to a successful party, as per ex parte Osborne in 1988, and that it's perhaps exceptional to award costs on against court application, as per the case of Manson Jones. Nevertheless, this being an application that was totally without merit, and also that with the difficulty of the inappropriate litigation practice being suggested, and the possibility of under section 51 of the Senior Courts Act for wasted costs to be awarded, there's a difficult question for those who might represent as to what to do in this situation. The costs in question would be costs borne by the public purse in particular. And it is not just or fair or right for the public purse to bear such costs in a totally unmeritorious application that may even be wasted costs by some sort of representative. Is identifying against whom such a cost simply can be made. And in circumstances where there's no obvious answer to against whom such a cost is ordered directly, just as against whom a civil restraint order is directed, I can't really properly advance any application.
Thank you. So, if there is anything that you want to say in respect of this, the applicants can have an opportunity to do so, but you will have heard that although the respondent might otherwise wish to make a cost application, no such application is in fact made, and you will also have heard that I don't propose to, at this stage, to make a CRO, a civil restraint order, although I will make some observations in that regard. But so in circumstances where I don't propose to make either of those orders, it may be that there's nothing to add. But if there is something that you wish to say.
I'd just like to ask for a bit of clarification that you're saying that no charges can be attached in this matter, and that this matter contains no merit, and that the coronavirus is not unlawfully incarcerating people in the non-geographical state once known as the UK. Is that correct?
I have made clear that both habeas corpus applications are dismissed on the basis that they are totally without merit. Neither of the applicants is detained.
So that using coronavirus and COVID as grounds to unlawfully incarcerate people is without merit. Is that what is being said here and dismissed?
What has been dismissed is the suggestion that either of the applicants are detained. There is no basis for suggesting that they are detained.
So that that they're free to go. By the definition of not detained, they are free to exercise their rights.
I've given my judgment on the.
I'm just trying to
what I
clarify what it is, because obviously the administrative system is so open to ambiguity, which is what we're seeing here at the moment.
I do require that clarity, as I'm not legally trained or qualified, and so far your findings, I feel I need to reject your findings on lack of cause. I, Emma Van, want to claim the wrong of trespass by way of assault, battery, abduction, theft, forced commercial intercourse, amongst other things. I require the immediate restoration of rights and property, a trial by a court of law, trial by jury to settle this matter in its entirety. I feel that these proceedings are unlawful. As I said, I am not legally trained or qualified. I am a complete idiot when it comes to legislative processes, and I don't believe that I have had due process of law in this matter at all.
Do you also feel free? Can I just ask, Emma Van 128, are you free, or do you feel unlawfully incarcerated in the unknown prison without a title that you are subject to at the moment in your community?
I absolutely do feel that I am unlawfully incarcerated.
Thank you.
Under COVID regulation.
Wherever we are.
I've given my judgment already.
We're just trying to, we're just trying.
As lack of
could I ask you both now to be quiet?
We're just trying to have you.
I need to address.
We can't accept something if we don't comprehend what it is. We need to comprehend what it is that you've actually said.
My judgment already. I've dismissed.
The fact that you have no assignment of consent or authority to act, and the fact that you are giving out a judgment under CPR rulings, which are born from fraud, is an incrimination.
There are 3 types of civil restraint order.
If we were civilians and subject to your acts and statutes, you would be laying charges.
A limited civil restraint order is limited to the particular proceedings in which it is made.
And who are you going to apply those charges and civil restraint orders to?
Where a party has made 2 or more applications which are totally without merit. See paragraph 2.1, practice direction 3C, civil restraint orders. An extended civil restraint order may be made where a party has persistently issued claims or made applications which are totally without merit.
Madam, we're asking you to define merit.
Where applicant 1191 doesn't bear responsibility for bringing this claim. There isn't any evidence before me that that applicant has taken any part in these proceedings. In any event, both of those applicants have individually, as far as I am aware, only had one order, the orders that I'm making in respect of each application in this, as a result of this hearing.
Madam, you cannot make an order. You've missed the point completely. You can only order your agents and your administrative agencies.
Responsibility for bringing totally without merit applications rests with the proposed litigation friends. Pursuant to the order I have made, they are not litigation friends, so they have no standing to pursue any of these proceedings further on behalf of either applicant. I have not been made aware of any previous totally without merit orders made against any of those who appear to seek to act as a litigation friend in these proceedings. It is difficult in any event to identify precisely who a civil restraint order would be made against. But it seems to me that in the circumstances, it is not at this stage appropriate to make a civil restraint order against any of those persons who sought to act as a litigation friend. That is, persons who've identified themselves as Imoven, Minister Imoven, Imoven 010, Graham Harkett, and Universal Law Community Trust. But I make clear that both these applications were a serious waste of the court's time and resources, resulting in the need for me to be diverted to sit in Cardiff Civil Justice Centre at a time when our High Court judge was not due to be sitting here, and taking up the valuable time of court staff with extensive, meritless email.
Madam, how can you compare that to unlawfully incarcerating people for 28 days inside a prison under false claim and fraudulent grounds?
Went to police.
It is you who shall be having the order of the civil restraint order placed against you by the Ministry of Remedy in order to prevent any further unlawful acts being continuated by yourself.
Proposed applicants and the proposed litigation friends are put on notice that if further totally without merit applications are made, they will be at serious risk of being made subject to a civil restraint order. As regards costs, Mr. Tahiri makes clear that whilst it's apparent that these applications have been a waste of public resources, and in other circumstances, given that they've been found totally out without merit, the defendant might well make an application for costs, but it is difficult to know in the circumstances of this case who any application for costs could be made against. And so in those circumstances, no application is made.
Proving that Minister Imoven cannot have a claim laid against it. Otherwise, they would have.
These applications were a waste of public resources.
While we're trying to stop them selling our assets.
It does not seem to me that I can fairly make a cost order against the applicants themselves, or that it would be possible to identify who they are.
For the fifth time.
And I don't consider it appropriate in the circumstances and given the practical difficulty of identifying who they are to make a wasted cost order against those who seek to act as the litigation friends. So those are the orders I make. Thank you very much, Mr. Tahiri, for your assistance, and thank you to those of you who have attended and made submissions. I'll now rise.
And there you have the evidence, which gives us the grounds to issue the warrant for the detention of such individuals without merit, completely without merit. Right. It is without merit. The whole administrative system is without merit. So we're going to go through what it is that we just witnessed there in the Ministry of Remedy. I'm just going to check the screen now. Sharing. Resume the recording. What we saw there was the very strange, obviously, exemplifications of what the definitions are that are being used. So as far as merit goes, the administrative system is without merit. The use of illegal fiction has no merit. The assigning of your consent to illegal fiction implies that you are an incapacitated legal minor, which is why you have then said, I need a government, a trust, a structure to administer any of my resources back to me. So what they said there is that MOVs are not considered to be incapacitated minors. So as for the consideration of where to attach a charge, if they could have attached a charge, they would have. So what you've just had exemplified there is that minister MOV reserves your rights from having charges attached to it, which is the recap that I tried to get her to go back over, because that the ambiguity obviously is so apparent there. The fact that they can't attach a charge obviously exemplifies that Minister MOV reserves your rights, and even if where they would like to attach a charge in the name of the public purse and say that the costs that we've incurred against the public purse, they've allowed that to continue, even though that they knew that those two ministers had been released from the prison known as Cardiff, and let it continue, which would imply that they were attempting to conspire to milk the public purse. If you already knew a week ago that this habeas corpus was no longer required, then why did you continue? And then sit there and say, oh, it's very bad what these people have done. They've made us, they've cost the public purse. For me to come and sit here when there was no judge sitting. Well, did you not communicate beforehand? I'm sure you did. Did you not know that the ministers were already released and therefore it wasn't the jurisdiction of Cardiff prison that we were referring to, but COVID? Now what you've got there is whoever she is, Ladyship Stein. Lady of what ship, we don't know, because as far as that vessel goes, it's smashed against the rocks, which she's just driven yet again the lifeboat into, by exemplifying that the administrative system cannot lay a claim against its creditors. If I was going to pick anybody out of that pot of the name jumble there, I've got a legal fiction that we use there that they have got the jurisdiction of. It's actually been opened and it's been laundered. Why don't you just attach some charges to that? Because it would have meant that the debtor, we would have had a receipt then to show that the debtor has laid a claim against the creditor. And that is what they're dodging all the time. That's why all of these cases have disappeared. The paperwork hasn't been produced. Obviously, we're not accepting that as a definition of anything, unless you want to. It's all of this that we're doing here is for you to be able to pick out and decide, right, okay, I've got this lady, whatever, at Stein, stating that we're not under unlawful incarceration by COVID, so I can go freely. I get out of my way. Here I go. We've got, what have we got? A document to say that the claim that COVID can be used as grounds to unlawfully incarcerate you. How you define that is up to you. You have now got, or will have a receipt, and you've got this recording to say that that is without merit.
Which also means that the extended time that they kept them in prison due to COVID is without merit. Exactly. And therefore unlawful.
The fact that they're trying to launder our equity to discharge the charges incurred by COVID having merit, now not having any merit. They've just completely destroyed Bill Gates is the indemnity pot by stating that that's why it was so important that they weren't allowed to just revert back to the original filing, which only mentioned HM prison, and I think it just mentioned Gwent Police, because it was at that point that original filing was done while they were all still at the police station. So they've sidestepped they put Gwent Police up there as the liability holder. Obviously, Gwent Police, they assigned the custody of the MOVs into Cardiff prison and other prisons. Prison unknown, it says.
So who's to say that prison unknown doesn't also include but not exclusively mean the one non-geographical state that it was called the UK? Because either it does or it doesn't, and it's up to you to apply it. If what that means in this ambiguous state, where I can turn around and say that even though I've read all of that information, and even though I've had all of the evidence put in front of me, and even though I know that we're only sitting in such conditions as we are because of the COVID hoax being used as grounds to unlawfully incarcerate you, I'm now going to sit there and say it's without merit. I'm now going to say that as somebody under this definition of the Mental Health Act, if you don't fit that definition of the Mental Health Act, well, you can't be you can't be a protected person then.
Yeah.
Well, the protection of trust is exactly that. It's your surety services. Of course, we're standing surety. And here, if you want to hit us with any charges, there's a big pot over there for you to discharge the charges against in exactly the same way that they were created. How? By pieces of paper and numbers on a screen, and an invoice, and a claim. And that is that, and obviously that is why I said in exactly the same way that they were created, they were going to be discharged. So they were going to lay a claim, they were going to make somebody liable for it, we're going to give it a value, and then they were going to exchange it for what? Sweat equity. So while you're comparing, having to come to the court, which you shouldn't be sitting in the first place because you have no administration of consent or authority to act anyway, and the fact that we'd already notified you that there was the act of fraud of you actually initiating this case, from the point where Jenkinson pressed OK to come into the Ministry of Remedy hearing, all of this case, every single bit of this is evidence of the case that we introduced at the beginning of this, which is a Ministry of Remedy hearing with this reference number, and the evidence that she has just exemplified there with complete contradiction, speaking of due process in a procedure, in a civil court's procedure that has been secured by its very own civil court process. And to then try to pick out the parts that I can still imply still have some credibility to it, which is what? COVID. Well, we're all behaving like this because of COVID. We kept them in the prison because of COVID. I got hit by a bus and I died, but it's COVID. Why? I'm stealing your assets and property because of COVID. And now you turn around and you say, COVID is without merit. Thank you for that wonderful exemplification of a corrupted truth, really. Because yes, what she should have said is, really, we acknowledge all of the things that you're stating here. And what we're really saying to you is that because we can't identify you in our system, we cannot recognize you. You are indefinable, and we cannot lay a charge against you. So the most that we can do is this, which is the most that we've done already. And even at the point where you come and you say, right, okay, what you're doing is unlawful. And it's not that we're coming to you to ask you to give us legal remedy, because we know that legal and remedy cannot exist in the same sentence anyway. So we would be exemplifying our incapacitated legal mindset if we were to do that. What we did there was put your police, your agents, your administrative system into the Ministry of Remedy to have you examine and exemplify yourself. And you openly admitted that the unlawful incarceration has merit. Or does it not? Does the lawful incarceration not have merit? Is COVID without merit, or does it mean that I have got the merit, but only if I choose to at my convenience? Did I just destroy my bar standard and my definition of the legal civil code procedure from the top to the bottom, inside out? Because by aiding and abetting now, which is what she actually did there, she aided and abetted. That's why I said I need to stop you to reserve your rights, because you're about to incriminate yourself. Because that was her being put on notice that if you continue at that point, that it's the same as the caution with the police. You're incriminating yourself. I have to bring it to your attention that that's what you're doing. And she carried on. Not only did she incriminate herself, she incriminated the whole system that she represented and its procedural due process and definition of what is valid and what has merit. So as far as the judgment in abbreviated comments of somebody who hasn't got the authority to act on assignment of consent or under warrant from secure party creditors, as far as that can be determined as a judgment, she just judged her whole system, her whole vessel, as without merit, because we haven't made the claim. We are saying, this is what you've been claiming. You've been claiming that you can identify these people and put them in the court and make them subject to civil acts and statutes. And really over here, when we got to this point, it was proven that you cannot. You cannot force commercial intercourse with a legal fiction that you do not have the right of use of. Otherwise you would have. You would have said, right, well, we're going to put a charge against that. And that's why they were fishing to see what could they discharge. If we had a slipped up there and not stipulated some of the debt, they could have said, right, okay, well, it's 10 quadrillion and we'll discharge the debt and put themselves back in the position of the creditors, of the, let's say, the squatters of the collateral, really. So as far as, coming and saying, right, okay, well, I'm here, I'm incommunicado anyway, because you can turn the microphone off at any time like they did, they muted it. So as for being in prison and able to conduct a habeas corpus, for the record, habeas corpus is without procedural process. It has no procedural process to it. I can write it on the back of a cigarette packet and I can serve it on the jailer who's brought me some toxic water while I'm inside there. It is your demand for immediate consideration of the lawfulness of your incarceration. Now, to inspire as many people as possible to put this very simple process, whatever it is that they say at the end at this point, look at what it is they had to do, not what it is that they said. They had to let you go. They had to kick you all out. They had to say, oh, quick, at 7 o'clock at night, out of the prison, not even a court. So it's not about, I want remedy, I want my compensation. It implied that there was still a legal minor. When you say I'm Minister from Aven, but I'm not legally trained, you just committed the contradictory. You are legally trained. Otherwise, you wouldn't be standing there. You've got more legal training and more legal awareness than anything that the legal policy enforcers have got. Because you bothered to show due diligence. They just went and said, right, okay, I put this magic uniform and I'll just follow orders, whatever it is, whether it's legal or lawful or what. I just want to pay my mortgage. I just want to buy my plastic chip. So don't fall into that, I'm a layman, I don't understand. You fully comprehend what the hell it is that's going on here, and we are not playing your game, that's it. I'm not going to come here and say, I don't understand your legal jargon. I understand your legal jargon to such a degree. What do I understand about it? It's fraud. That's it. Not that I need to be able to cite the Civil Code, Civil Procedures Act 8.216. It's bollocks. All of it has the adding to the ministration of the law is what is without merit. And you just saw it there in its purest exemplification at its highest level of being able to be considered as a thing itself. It was without merit. The whole filing of the process, the fact that they are going to stamp a document and refer to the document that's backed by another national insurance account, that the court fund account is being used already, so it's not coming out of the public purse. And don't insult our intelligence to try to even imply that. It's a false claim in itself. It's coming out of the assignment of consent of the right of use of the national insurance account that we have temporarily granted to them in order for us to discharge the charges with, which is what that national insurance account is for. Proving that you have or should have a charge account that you can discharge your charges with. But because you have that facility, which I just explained how we would discharge those charges, it's my share of the planet and its resources that's being used at the moment, so I'll discharge that with that. And not only that, there's 10 quadrillion slave tokens worth of this share of the planet and its resources sitting over here in a pot to discharge any future charges. What, is that not enough? Do I need to indemnify myself more? But it also means that there's 10 quadrillion sitting in our pot that's just been acknowledged that would be used to discharge the charges against if there were any charges able to be laid, meaning that the coronavirus indemnity pot has not got 10 quadrillion inside it because it's just been acknowledged it's sitting over here inside the Universal Community Trust, which we are more than happy to discharge anybody's charges through who uses ministering of them as their legal fiction in order for them to be able to reserve their rights and not become the unsecured creditor of an administrative system that we have spent this time and energy in dissolving. Has anybody got any questions?
YouTube.
In the recording. So we're just getting some feedback about what went on at the court level. So the events that were in attendance there, I've got this to report. What happened with the COVID certificate?
Yeah, as we went into the court, the first thing they said was, "Where's your masks? Can you put some masks on, please?" And we said, "Oh, we don't need masks because we're immune to coronavirus. We've got our own private health care, and we've had the antidote, so we're immune to coronavirus." And we showed them our immunity certificates, and they just glanced at them and said, "Oh, okay, come in." It was as easy as that.
That's what we actually served a document stating that it was their gamble that they had to take as to whether a coronavirus immunity record or certificate was valid, meaning that if they said, no, it's not valid, then that was issued by a private corporation or a private healthcare provider, then they would be setting the precedence that all other certification processes, such as the ones conducted by Pfizer, are also invalid and have no bearing or value or standing without merit. And so that's why you were let in.
But it's kind of cool that we entered a civil justice centre, as they call it, with a coronavirus immunity certificate. You know, it just,
people have been on boats and planes with those, with trains as well. They work because it's just, again, you're rebutting the presumption that all of this process that we teach everybody and share with everybody is you're just rebutting the presumption that you used to make. It's not that I've learned anything new. I've just stopped doing the thing that I kept doing, which was to incriminate myself every step I took, every breath I took, by sharing this presumption that legal is lawful. It's not. It's proven here and exemplified. It's got absolutely no standing whatsoever. So, and 1160, they muted me, didn't they, at that end?
Yeah,
they cut you off, and then luckily we could hear you on this end, on the other line, on here, on the Ministry of Remedy hearing. But otherwise, they just cut you off because she was like, "Oh, let me just complete what I'm saying."
Yeah. And that's why everybody's incommunicado, and that's why it can't be a court of hearing, because you can't be heard. Because they can just turn your microphone on.
Yeah, there was a few times where she asked you to be quiet.
Yeah, no, but the times when she actually just, and it wasn't even her who cut you off, by the way, it was the,
it was the controller.
Yeah, it was the controller, and actually our messages were not even getting to her because